All right, welcome to the broadcast. My sign language interpreter is Teresia Washira. All right, to the BBI case where President Uhuru Kenyatta lawyer Mohamed Nyaoga has disagreed sharply with the outcome of the BBI case at the High Court that cited that the president can be sued while still in office. In his defense, President Uhuru Kenyatta has said the acts he performed were according to the Constitution. Caroline Suma with the story.
It was a back-and-forth session between the seven-judge bench and lawyer Mohamed Nyaoga representing President Uhuru Kenyatta at the Court of Appeal during the second day of the BBI hearing. Nyaoga stating the president is immune to being sued as Article 143 of the Constitution defends him.
My lords, the judges issued a declaration that the president could be held personally liable for functions or performing functions of his office.
I think it's important that there's a distinction there.
Yes.
So we need to, did they say he could be held personally liable for performing his functions, or did they instead say he could be held personally liable for performing functions that are outside what the Constitution gives them? I think that's a very important distinction.
They declare here that the acts were official acts. And if they were official acts, the AG was the right party to represent him and not to enjoin him at the personal capacity.
Do you agree with that finding at paragraph 494?
Yes.
That in establishing the BBI steering committee, your client did that in his official capacity as President and Commander-in-Chief of the Defense Forces?
My lord, the Gazette notice speaks for itself.
I'm asking whether you agree with this finding.
Now, my lord, the submissions have been made, and my learned friend, Mr. Kirago, is going to address that particular issue.
Kiragu Kimani, also representing the president, came to Nyaoga's rescue and cleared the path by stating the president is entitled to supporting any cause as he is a citizen, a leader, and can be involved in any amendment process.
No one has pointed you to any provision in the Constitution that bars the president from initiating an amendment to the Constitution through the popular initiative. It is moot whether he was acting in his official capacity or not. That's settled. That's not before you for determination. But I think, my Lord, Mr. Justice Kiagi is entitled to a straight answer. If it's a question of a dog, in my view, so. But with respect, that's not where we are at today.
Today marks the end of the hearing for those who appealed. Tomorrow, the correspondents are expected to plead their case before the judges. Caroline Suma, Switch TV.
There is a high likelihood that Kenya will not hold a referendum, even with a positive outcome for the BBI proponents at the Court of Appeal. Political commentators have said that more than 15 issues that were raised by the High Court might be difficult to be overturned by the Court of Appeal.
Million signatures amounts to a wrongful.
With the second day of 4 days hearing of the Building Bridges Initiative case, political commentators believe the outcome of this case will shape the political dimension in the country for the next few months. The BBI report has been the talk of town for the past 2 years since its inception after the March 9th handshake.
So we have 4 appellants. Now they have flagged out about 14 grounds of appeal. One of the grounds was that IEBC as constituted is illegal, is not legally constituted, meaning that it has a bearing even on the past by-elections. Because the quorum says that IEBC, for them to have a quorum, the law says they have to be 5 members. As we know now, we have only 3 commissioners.
Asitiba Edward, a political commentator, believes if the court appeal subverts the High Court ruling, the Tanga faction will be up in arms to reject the outcome.
I'll hasten to add that they don't need to throw out all the 14 grounds, even if 2 or 3 grounds are allowed to stand. They are enough to nullify the entire BBI process.
And as was
On the flip side, if the Court of Appeal upholds the High Court ruling, the handshake side may contest the outcome of the Supreme Court, but as Tiba claims, this will be of no help.
No, time is not on their side. That's another pressure they have. They are trying to pressurize to see that the Court of Appeal stays the ruling and in its entirety. If it stays, it means IBC can go ahead with the preparation for the referendum. But should they decline to stay the judgment and leave it, it means that until they hear the appeal in its entirety and make a decision, the matter is held.
President Uhuru Kenyatta and his handshake partner Raila Odinga are confident in winning against the stoppage of reggae at the Court of Appeal. The other side, being led by Martha Karua and LSK President Nelson Harvey, are also confident of winning the case.
So it's really a delicate matter, which I don't think any legal mind, any even top-notch lawyer will tell you for certain this is how the case will go. No. There are very weighty grounds. There are very good brains, legal brains, which are involved. And we wait to see. It's a matter that all of us will want, and it's likely to go up to the Supreme Court.
There are 17 counts which have to be averted by the proponents' lawyers, including a ruling that President Kenyatta had violated the Constitution by initiating a process which ought to have been started by ordinary citizens. The High Court also ruled that the BBI Constitutional Committee, a body created by the President, was illegal, adding that the President had failed the leadership and integrity test. Namukana Samuel, Switch TV.